Crossley Gates is an insurance partner at DLA Phillips Fox. He specialises in policy drafting, insurance regulation and claims advice. Prior to joining DLA Phillips Fox 12 years ago, he worked for 18 years as the head of legal for NZI. He's also specialised in insurance law for over 30 years. In a good position to offer plenty of perspectives on that question, would you please welcome Crossley Gates?
Right, first of all, I'm not going to bore you with a whole lot of policy drafting because I know you'll all be asleep in 5 minutes, okay? What I am going to talk to you about is actually what leads up to the policy drafting in the first place, and that is the creation of the contract and the certainty that I sometimes see missing about that process. And it's costing the industry a lot of money. Right, so by way of introduction, as Andrew said, I've been specialising in insurance law now for 30 years, spent a good deal of that in the industry itself, working for NZI. The first thing that struck me about the product when I first worked for NZI is what a great product it is. Once you see the kind of losses that occur and the benefit of the product, it's just brilliant. And of course, imagine where, although we don't get this press, but where Canterbury would be today if insurance didn't exist as a product. But I also get dismayed when I see how often we sometimes let ourselves down. And really the purpose of this address is to highlight some of those concerns and the hope that maybe as an industry we can lift our game. As I sometimes say, if an insurance company made cars, then really the policy wording is their car. It is the product, and just like car manufacturers, the way you put that together is really, really important. And as I hope I will demonstrate to you, the way you put your policy wording or the way or the process you go through to create it is also important. And both underwriters and brokers have an important role to play in this. And I just want to say this is not a beat up on brokers and it's not a beat up on underwriters. It's actually a beat up on both of you. So I'm safe. Just a couple of caveats that I want to give you. I'm going to make a lot of generalisations. So obviously, as they are generalisations, they don't apply to everyone. And the second caveat is that to some extent this is my personal view and not necessarily the view of my firm. Right. Got that out of the way. Okay, so at the heart of insurance, of course, is the promise. And there's two issues that can arise. One is, what is the promise? And then second, did you keep to the promise? So just to drive home the point, I'm not going to be talking about keeping the promise. That's about paying when you ought to pay and not paying when you ought not to pay. But I'm going to talk about creating the promise and some certainty around that. Okay, so this is what I'm going to be talking about, and these are the problems that I've seen come across my desk, in particular in the last 3 or 4 years since the earthquakes. It's fair to say that I've seen an intensity of scrutiny of policy wordings and since the Canterbury earthquakes, like I've never seen before. Like we're talking no stone unturned approach. We're talking every word being pulled apart. We're talking about every possible argument being taken. And right at the end of these speeches, of these slides, sorry, I'm going to show you where just a few words would have totally removed a court case that went all the way to the Supreme Court of New Zealand. Just a few words. That's really interesting. Okay, so what are the problems? Well, I see confusion about the legal position of insurance brokers. I'm talking about independent insurance brokers. The legal position is not misunderstood, but I think the industry, as a generalisation, misunderstands it. So this leads to a mismatch between industry practices and the strict legal position. And I'm afraid when it all goes wrong, it is the legal position that wins at the end of the day, not the industry practice. I see the offer and acceptance process. I'm talking about the placing slips and the negotiating of the cover is not well understood and is, for me as a lawyer, breathtakingly lax. And I'll explain why I'm saying that shortly. Of course, I'm talking about the intermediated market, and I'm talking in particular about large risks. So as a result, there can be confusion about when the contract is formed, about the terms of it, and even when it is formed. Okay, so let me just very briefly, I don't want to turn this into a legal session, but let me just briefly explain to you. This is a summary of the law relating to insurance brokers, independent insurance brokers in New Zealand. So they are the legal agent of the insured, okay? That's assuming, of course, they are acting for the insured, which they usually are. There's one exception to that, and that is the Section 10(1) of the Insurance Law Reform Act, which has caused confusion for many, many years. But there was a Court of Appeal case that made it clear what that meant. And what it means is there is a window when the negotiations go on, when if the broker starts acting for the underwriter to any extent during that window, then they're deemed at law to suddenly now become the agent of the underwriter, which is quite a dramatic effect. But this window closes once the contract is formed. Okay, so that's the exception to the first bullet point. So generally agents of the insured, but for this window when the contract is being negotiated. Now, because they're the agent of the insured, of course, if they have their own wording and they draft it, or they draft an endorsement, and it's ambiguous, and the rules of contract interpretation can't work it through, and so you're left with the default contra proferentum rule, then it will be construed against the broker as agent of the insured. So that's a downside for brokers in terms of policy wordings. The ambiguity is going to go against them, or their client, I should say. And of course, like all agents, the brokers owe a duty of care to their principal, the insured. And apologies to those of you who've seen this slide before, but I keep trotting it out because it's just a visualization of what I've been saying. So you've got the parties to the contract, you've got the agency down the bottom there between the insured and the broker, and of course you've got the negotiation going on between one's principal, the insurer, and the agent of the other principal, the broker. And the broker's role there is to take the instructions, negotiate the cover, and report back. Now, of course, you can have agents on both sides. So we have underwriting agencies, and of course, they're just simply the agent, the flip side, they're the agent of the underwriter. So that now the negotiation, of course, is going on between the two agents. And that offer and acceptance process, that's where it occurs. So what are the practices that I see that are out of step with the law? Well, here's one. I often see underwriters and brokers referring to their legal relationships incorrectly. Now, I think Australia's in a much better position than New Zealand. And I've given you some examples here under an Australian policy wording. It was issued by an underwriting agent. So, of course, that person was the agent of the underwriter. And it says the underwriting agent is authorised representative of the underwriter, correct? And arranger of the insurance provided under this policy. In arranging the insurance, the underwriting agent acts as the agent of the underwriter, not as your agent. Crystal clear. This guy is not the agent of the insured, right? But here's what one New Zealand underwriter says in its policy wordings right at the end. We partner with a network of skilled and experienced brokers and other insurance intermediaries who distribute our products. We pay remuneration to our brokers and intermediaries when they issue our policies. Now, a lot of ours in there, but they're not, as I said to you, these guys are not the agent of the underwriter. And I think that language is awkward and is unfortunate. And so that's just an example, I think. I often hear underwriters talk about our broker partners. Now, I know why they say that, but I guess it's just not the right, in terms of the legal relationship, they're not your anything. They're actually the insured's agent. And I know you have to deal with them and they're your channel and all the rest, and that's fine. But I guess it's just, I think it can lead to a lot of confusion when some of this terminology is used. But let's dig a little bit deeper about that's a relatively superficial issue. Some other practices that I think are out of step with the legal position. So, of course, the contract usually consists of the standard policy wording and the individual schedule. And, of course, the schedule is particularly important because it's got all the individual aspects that are unique to that particular insured. Now, it's part of the contract, the schedule. And so often, as I understand it, often the wording's standard, so that isn't sent to the broker because it's a standard wording or a broker wording, so everyone knows what it is in advance. But the schedule is. Now, as I understand it, some brokers don't send that on to their client, which I find staggering. I mean, that's actually part of the contract, right? And indeed, even worse, they send something that they create themselves. Which I think is a really risky thing to do because you're not sending the contract on to your client, you're sending another document, right? Now, I guess that's fine if that document accurately reflects what's in the contract, but if it doesn't, you're running a real risk, aren't you, that it doesn't reflect what the cover actually is, and you're not reporting back to your client correctly. So I see that as a possible problem area. Even worse than this, I've seen on occasion where the underwriter actually gets the broker to prepare the schedule. Now, this confuses the roles because the broker is acting as agent for the insured, but now you're actually asking the broker to do something for you to create part of your contract. And I think that's an undesirable state of affairs as well. So, what would happen if that schedule was contrary to the underwriter's instructions to the broker? It's a contract document, it's going to bind the underwriter. Then presumably the underwriter is going to look to the broker and say, well, you didn't do what I asked you to do. But the broker's now in a bit of a conflict situation because they're acting primarily for the insured. And they now have two masters. So you can see it leads to all kinds of potential legal issues. So moving on from that, let's look a little more closely at the contract creating business, which is what brokers and underwriters are actually in. They create contracts. And some of the worst examples I saw arising out of Christchurch showed me that some brokers and underwriters don't understand which communications actually create the contract. They don't understand actually when it's formed. Because this became critical, because inevitably there were people that had losses happen just a little before or perhaps a little bit after that particular contract was apparently entered into, and it became critical to work out actually when did the contract get formed. And don't ensure that key terms are actually well settled and spelt out clearly in the contract. So I'm just going to very briefly take you through what it is that creates a contract. So the three main requirements are offer and acceptance and consideration. There's always consideration because there's always a premium paid, so that's taken care of. It's the offer and acceptance process which is what's absolutely critical. And here's a little bit of Contract 101. A contract's formed when you have what's called consensus ad idem, a bit of Latin for you. Idem means the mind, and consensus, of course, is the meeting. So it's a meeting of the minds. So the two have to meet together to form the contract. If you can't have a meeting of the minds, you don't have a contract. And you do that through the offer and acceptance process. And I'm talking here about initial submissions, about placing slips, about closings. These are the absolutely critical documents, right? To some extent, the policy wording is secondary, because this is where the contract is formed in these documents. And so you've got to have this process where you understand that you send off an offer, and if it comes back accepted, you've got a contract. And if it comes back altered or not accepted, you don't have a contract. If it comes back altered, it'll be a counter offer, which you then got to decide whether you want to accept or not. And you might not accept it, and you might counter offer back. And that process can go on forever and a day, if you like, until either you give up or finally there is a meeting of the minds. Okay? Now, some of the communications I saw and the emails backwards and forwards between the particular person in a broker company and a particular person in the underwriting company were lax in the extreme in this, and it actually was difficult to work out where there was an offer that was then accepted. And you know, boy, we're talking binding, you know, potentially millions of dollars of exposure here. We've got this incredibly loose process going on. As I say, as a lawyer, it's quite breathtaking. So, oh, there we go. So the normal process is, as I understand it, you know, the broker seeks cover, although they may start out with a detailed offer. It can go either way. But then usually the underwriter provides terms, which is the offer, then the broker accepts the terms or doesn't, and that's the counter offer, and then it's for the underwriter to either accept that counter offer or not. Now, as I said, this should be a formal process because this is where the rubber hits the road. This is where, if you're a foreign exchange dealer, you're actually pressing the button, committing yourself to a particular you know, purchase or whatever, or sale that could have significant ramifications. And to me, it's an area where there should be utmost good faith between the broker and the underwriter. I mean, after all, it's in no one's interests for there to be uncertainty about this. I mean, obviously the underwriter doesn't want uncertainty about it. They need to know what their exposure is, they need to know what the maximum exposure is and what the terms are. And for the broker, it doesn't do your client any favours for this to be ambiguous, does it? I mean, I saw a whole number of disputes where the poor old insured was just left in this terrible situation where it was unclear what the cover was, and there was a huge argument going on, and I'm going to demonstrate one of them, between the underwriter and the broker. And I felt really sorry, and I saw the emails, and they were horrific, you know, from the insured. They were just scathing of the industry, and I thought, you know, we've got to do better. Right, so that hiding of the counteroffer, I just wanted to talk about that. I've given advice to underwriters several times where they send the placing off to the broker, and it comes back, and it's not checked properly, and there's a change, but the change is not highlighted. And so what happens is the company then puts it on the books, the premium is then paid, etc., etc. Then a claim comes along, and then someone says, well, hold on, that's not covered. And then, of course, the broker says, well, yes, it is, because look at the terms you know that I sent back, and you went ahead with that. And the underwriter probably is bound in that situation because there's an acceptance by conduct, by putting it on the books, by collecting the premium. You've said you're actually going to accept what came back. But you know, if you're going to make a change and you're going to send it back, I would suggest it's incumbent on the broker to point that out and not sort of actually hide it. Now, I know that's a slightly scurrilous accusation, but that's what I was told on one or two occasions, that, you know, it was a small change and you had to really scour through it to find that change. So I guess what I'm saying is, let's not play games here. It's not in the interests of the industry. It denigrates the product. So here's, sorry, oh no, I've got it, yeah. So here's one example. So during negotiations for cover, and this is the classic, the schedule of buildings, you know, that you're insuring, and that has got a column of sums insured, right? And that had a figure of 7.1 million. That building was destroyed, and like so many in Christchurch, the cost of replacing it was nearly double. And of course, all the schedule had was that is actually taken from the document. Sum insured, section 1, 2.26 million, right? Now, is that a global sum insured, or is there a building by building sum insured here? There was a schedule, okay, prepared for underwriting purposes only, okay, whatever that means. It wasn't strictly incorporated into the contract, although that is happening now because of this issue. And there is a schedule with sums insured for each building. So what was the intention here? Now, it's not for me to say, but my point is, don't let that kind of ambiguity happen, because this poor insured got really caught while a huge scrap went on about whether this was a building by building sum insured or a global sum insured. And I have just really effectively covered that off in that slide there. I'm pleased to say this was resolved, and resolved satisfactorily. But as I say, it took some time, and in the meantime, the insured was left in the lurch. So now, just very briefly in the last few minutes, I am going to show you some live demonstrations of how a few words can make a big difference. Some of you will know about these cases. This is the Zurich case regarding the Salisbury apartments. Went all the way to the Supreme Court, right? This was all about whether the earthquake top-up was paid the difference or it paid the sum insured again. The wording was not entirely clear about that. Because it said, then the insurer's liability will be limited to the amount of loss in excess of the natural disaster cover. But the amount of the loss in excess, but was the whole sum insured there, or was it the difference, right? Now, if it had said that, there would never have been a court case, never. All those QC's fees, none of it would have happened. A few words. It's just staggering. Of course, one of the difficulties with this is that, you never see the arguments you never have by getting it right. So you never quite know what that cost is. And this is another one which is still grinding its way through, and those of you who are in the earthquake space and know all about these claims will know this one. This one went to the Court of Appeal. This is about the reinstatement of sum insured clause in policies, and it says that the sum insured is automatically reinstated from the date of the loss. Now, I mean, literally, that's reasonably clear, but my instructions are that that's not the underwriting intention, and that the underwriting intention is that. Okay, it's reduced and we automatically reinstated from the making good of the loss. So once the building's been rebuilt, then the sum insured, of course, is now put back up because it's now got something to bite on, so that there's full cover for the rest of the policy period. There's a lot of money riding on this, and I should declare my interest. I'm acting for the underwriters in one of those cases, and we're off to the Supreme Court on this one, so we will see what transpires. But there you are. There's some live examples of just a few changes creating quite a difference. So just to sum up, I don't want to be too pessimistic, but I thought I should share with you the kind of thing that I see coming across my desk. I realise I'm the ambulance at the bottom of the cliff, so I guess I see everything that goes wrong. I don't see everything that goes right. But, there's a lot of room for improvement here, and I'm hoping I can persuade you that's the case. So as I've said, insurance brokers are usually the agent of the insured, and really business practices should really reflect that. And I see some that I think are troubling. Creating an insurance contract is a very formal process. Now, I know one underwriter has had a whole project going on this, and it's about to come to fruition, and they're going to change their whole procedures, and that's great, and it'll be interesting to see how the market reacts to that. And as I said, the current processes are generally pretty lax. Attention to detail over the terms and the drafting can avoid unnecessary disputes, and of course a lot of money you spend on lawyers. So there we have it. So that's 1 minute to go, not too bad. Got any questions?
Crossley, the Section 10 exclusion,
Yep.
that makes the broker the agent of the insured. Could you give a practical example of that, what sort of action would create that, so
Yes,
that we understand it?
Yes, I mean, the agent of the insurer, yes. Well, the case is called Harwood Orchards and maybe in Wallace, and it involved a broker that was involved in a scheme, and I think this is the most dangerous situation. So there was a crop insurance scheme, right? And they had, and that was placed with an underwriter. But the underwriter, didn't know a lot about the risk, and of course, and the broker did. And so there was an element of toing and froing between the broker and the underwriter about the nature of the cover. And anyway, what happened was the broker wrote a letter to the insureds representing that a certain type of loss would be covered. And it turned out that there'd been authority for that communication to go out from the underwriter, right? So the court then said, oh, well, the underwriter's now authorised the broker to do this, so they're caught by 10-1. So now that letter was effectively on behalf of the underwriter, and because the broker had now become the underwriter's agent. It's like a toe dipping thing. If you just dip your toe in a little bit, you're suddenly completely the agent for the whole time. But as I say, it's only for this window, right? Once the contract is formed, it's all over and it's back to the common law position of being the agent of the insured. Yeah, it's not well understood, this. I mean, and you know, when I explain this in seminars and whatever, you know, people are all aghast. But you know, that Court of Appeal case was several years ago now.
Referendum rule going against the insured. Yeah. Because invariably, even when we're dealing with broker-agreed wordings,
yes,
our claims staff take contra preferendum and ambiguity in favour of the client. But what you said on your slide was that, well, if it's broker-agreed wording, then that basic principle of consumer protection, ambiguity in favour of the client, just doesn't apply.
Yeah, the rule isn't actually about consumer protection. It's actually a rule that applies to all contracts. It's not an insurance-specific rule. Okay? Remember, insurance is just a contract, so all contract law applies to insurance, although it has a little extra body of law because of the special nature of an insurance contract. The contra preferendum rule is just a rule that says that, you know, if you've got the pen and you're drafting whatever it is, and it doesn't matter which party it is, and you make a poor choice of words, and that leads to an ambiguity, well, you, the person who had the pen, should pay the price. Okay? So it's nothing to do with brokers, insurers. What's the word? You know, it's neutral. It's neutral about which party it favours. It just happens to be whoever drafts it. So the point being, of course, that if the broker drafts it, it's going to work against them. Just say. Sorry. No, it doesn't change the contra preferendum rule.